case against Illinois' gun and magazine ban continues, with federal Judge Stephen McGlynn moving forward with the case on the merits, as you've got the Northern District cases that are on hold because plaintiffs there are seeking the U.S. Supreme Court to intervene again. But down in the Southern District, Judge Stephen McGlynn saying, no, we're moving forward. Welcome back. Bishop on Air each and every weekday morning with you here across the internet. Be sure to like, subscribe, hit that notification bell. If you want a Bishop on Air mug, go check it out. Just go to bishoponair.com. So we have an order that was issued yesterday by the judge, Stephen McGlynn, in this case. Let's go ahead and pull that up for you so you can read this. So this is, of course, an official order from Judge Stephen McGlynn, issued on the 29th, leap year. Gotta love that. But anyways, he says, in accordance with the court's order issued during the scheduling conference held on February 28th, the following discovery deadlines are implemented. So we're getting more indication as to the timeline of how rapid we're going to get to the merits of this case challenging Illinois' gun and magazine ban. Again, that was instituted in January of 2023, so it's been over a year and a month since we've had this gun and magazine ban implemented. And don't forget about that gun registry as well, which is also being challenged, something I talked with Thomas Maag about, the attorney for the case Langley, which is part of the plaintiffs group. You've got 4 different cases lumped together in the Southern District. So the timeline now we're seeing on this is being laid out by the judge. So let's look back at this order here. Parties shall submit their initial disclosures and written discovery requests with the court, carbon copied, no later than March 13th. So March 13th is one of those deadlines. Parties shall submit the identities of their affirmative experts and their subject matter expertise with the court's carbon copied no later than March 27th. So 2 weeks from now and then 2 weeks from then, understanding a supplemental expert identification may be necessary. Then parties shall respond to requests for written discovery with the court carbon copied no later than April 3rd. So you can kind of see it's going to be week after week after week of us getting some information here. Order to issue setting a status conference to discuss the status discovery will be in mid-April. This status conference shall be held via Zoom and will assess the progress of discovery and gauge the amount of cooperation among the parties in preparing this matter for a hearing on the merits. The court may discuss the targeted trial month and set the date for the final pretrial conference at the upcoming status conference. So again, the dates, got to have some initial disclosures by March 13th filed. Then by March 27th, got to have the identities of experts that the litigants are going to use. Then the parties are going to be responding to requests for written discovery no later than April 3rd. And mid-April, there will be some kind of, some kind of status conference. Now, what all this means, I talked with Thomas Maag yesterday, and he's, again, the lead attorney in the Langley case, and he was in the courtroom yesterday, along with, in the docket entry, kind of, a minute of the proceeding that happened on the 28th, that is available at the docket, and it talks about, you had Judge Stephen McGlynn there, Sean Brady with FFL Illinois Plaintiffs, Thomas Maag on behalf of the Langley Plaintiffs, Matthew Rowan participating on behalf of the Barnett Plaintiffs, David Segal with Siegel, I think, participating on behalf of the Harrell Plaintiffs. So you also had the state there as well. Christopher Wells and Catherine Hunt Muse participating on behalf of J.B. Pritzker and Brendan Kelly and Kwame Raoul. But interesting also, this case has several county defendants as well that have had to take part in all of this, because some of these lawsuits do include suing local counties. But anyways, Thomas Maag was there, chatted with him yesterday, and here's some of what he provided as to what exactly it looks like from the perspective of the litigants.
What we know is that the court ordered that parties are to submit their initial disclosures and written discovery requests no later than March 13th. So in about 2 weeks, parties are to disclose the identities of their affirmative experts by March 27th. Court's going to set another discovery conference and enter a further, more detailed scheduling order on discovery, but suffice it to say the court made it clear that it was ready for his case to start proceeding, and it didn't need any more excuses to delay discovery and proceeding in this case.
So, talking with Maag yesterday, he also laid out what he sees in the order that Judge McGlynn issued last week, that roadmap. What does that roadmap signify to the Langley plaintiffs?
Signifies to me that the court's given some thought as to the different scenarios for lawful self-defense. One, of course, is being in the home. The other is what I'll call traditional carry outside the home. And then he's also given consideration to some of the more extreme possibilities, such as riots and civil disturbances. Of course, East St. Louis 100 years ago was made somewhat famous for a rather notorious riot. So I guess Judge McGlynn, his family being from the area, is probably familiar with East St. Louis history on that regard.
And, of course, this case being heard in that East St. Louis Southern District courtroom. But McGlynn also talked about, are these weapons good for battling tyranny?
Absolutely.
So it's kind of fascinating to see that as well. Thomas Maag also giving us an update on that Fifth Amendment challenge that he brought and where that could possibly go in the mix of all of this.
I think it greatly depends on how he rules on the Fifth Amendment motions, plural. If he finds that there's some issue in dispute, material issue in dispute, he's probably obliged to deny both summary judgment motions, but at that point, it would be part of the trial on the merits.
So again, what we're looking at here is you've got the Second Amendment arguments, right? A well-regulated militia being necessary for the security of a free state. The right of the people to keep and bear arms shall not be infringed. That's the Second Amendment. But the other arguments that at least Maag initially filed in his state-level challenge that was transferred to federal court because it was bringing up U.S. Constitution questions wasn't just the Second Amendment. It was also the 14th Amendment and vagueness, and also that Fifth Amendment argument dealing with the gun ban registry, which from the last time I checked, state police had yet to update the gun ban registry. Let's see if we've got any updates here. And the latest numbers from Illinois State Police, scrolling down, and they have not been updated. So 2.4 million FOID card holders, that number's not been updated, and neither have the numbers of those who filed affidavits telling Illinois State Police they have banned items after the January 1st registry. So that's still 1.4 some odd % of total FOID card holders, but that FOID card number has not been updated. And you look at some of the other statistics as to the number of FOID card applications, even in February, you're looking at, in January, there were 15,000 new FOID applications received, and the numbers approved 15,000 plus. What about all those other numbers from the past year? Those have not been added to the state's total tally. So who knows what the actual compliance rate is. Regardless, back to Maag, of course, talking about that Fifth Amendment argument, how you are not to be compelled to incriminate yourself. So more to this issue of the Fifth Amendment and where Thomas Maag sees his challenge of that going, while the court continues to focus just on the Second Amendment issues. So what's going to happen with this?
On the other hand, I think we've made a very good showing that the state wants people to register their firearms even after December 31st of last year. And just like the original National Firearms Act of 1934, which the U.S. Supreme Court struck on Fifth Amendment grounds in 1968, by registering your firearms after December 31st of last year, you are admitting that you possessed a firearm unlawfully and thus are incriminating yourself. That's prohibited under the Fifth Amendment.
And we'll see where the court goes with that Fifth Amendment argument in this case challenging Illinois' gun and magazine ban. again, the past year, we've seen these cases go up to the next courts and even up to the U.S. Supreme Court on preliminary actions, right? And those preliminary actions were just, we want to hold this right now from being enforced while the case plays out because people allegedly are being harmed. All right, that's the idea of a preliminary action, a preliminary injunction. But then in the Southern District, when Maag initially issued that, it went up to the Seventh Circuit, and the Seventh Circuit put a stay on that, essentially saying McGlynn's order's not in effect right now until we take the case up and decide on it. And they took the case up, and they decided that the state had a likelihood of winning on the case. But it wasn't that the state won on the case, right? Then you had the plaintiffs say, well, we want the U.S. Supreme Court to intervene on these preliminary actions. The U.S. Supreme Court said, no, we're not going to do that. Wait until the full record's built. Maag took that as, let's get a full record built. So that's why we're moving forward on the merits of this on a request, a motion for summary judgment. And a motion for summary judgment essentially is, this case is done in the court. We went through it all. We figured it out. Here's the judge's ruling. But what's that going to look like? Maag gave us a little bit of a timeline on when to expect these next things to pop into place.
I think that this case will be tried sometime middle this summer, yes.
So middle this summer, we could see some action in the courts where you'll have a trial-like of atmosphere. But what does that trial look like? Is it a jury by trial? Is it a bench trial? How is this thing really going to play out in the space of the judiciary?
It will not be a jury trial. I don't believe anybody's demanded a jury. It will be a bench trial. The way I foresee it, there will be some legal briefs filed basically making arguments to the court. The various parties will call witnesses, submit other evidence, either stipulations, admissions by the opponent, or live testimony, depositions, possibly video testimony. And the court will hear the evidence, weigh the facts, find the credibility of the various witnesses, and make its conclusions of law and issue an appropriate decision.
And again, that decision will be on the merits, summary judgment, the circuit court saying, no, we're done now. It's off to the appeals court. What the Seventh Circuit U.S. Court of Appeals does with the record that Maag and the plaintiffs are going to build in this case, we shall see. But obviously, a lot of people frustrated at how long this is taking. I will continue to track it with you. Appreciate you guys being here. Like, subscribe, hit that notification bell, and join me each and every weekday morning as we broadcast live. But if you can't make it live, totally understand. Hope you enjoy the segments. But one thing about being live with us is you can join the Discord on Fridays. We open things up, so be sure to hit that like, subscribe, notification. Go to the Discord channel, join that preemptively. And we'll get to that a little bit later on here with the live show. But I appreciate you guys checking this out. Bishop on Air everywhere. All right, don't forget that. Real simple. bishoponair.com.